All right, call the roll. Senator Lucas? Here. Senator Normet? Senator Obenchain? Senator Boysko? Senator Surville?
Aquí.
And Mr. Chairman, you have a quorum.
Okay, ladies and gentlemen, I'm going to announce the advent of the Civil Laws Subcommittee of Courts of Justice. I'm going to call it Courts of Justice just to be a recalcitrant. We have 3 bills on our docket today, and I'm going to take them in kind of reverse. I don't want to say reverse order of complexity, but let me start with Senate 1435, which is patroned by Senator Hanger, which has to do with electronic execution of estate planning documents, Uniform Electronic Wills Act. Senator Hanger was here a moment ago. He's chairing a subcommittee upstairs. I know I've been reached out to by members of Virginia Bar Association, Trust and Estates Committee, and are they in the waiting room?
I believe so, yes. We're moving them in right now.
All right, well, why don't we do this? I'm going to let them, since this is really their bill, let them go ahead and speak to it and tell us why we need to amend our code in regard to electronic execution of wills.
Mr. Chairman, before you start, there is a substitute that's been posted online for this bill.
Okay, do I have a motion to adopt the substitute? All right, I have a motion and a second to adopt substitute. All in favor say aye. And the substitute of Senate Bill 1435 is now before us. And if we could go to the Virginia Bar Association to tell us about this bill.
Senator, hey, this is Jeff Palmore. Matthew Farley is our resident expert on this bill, and he's having some trouble getting into the room. So I'm trying to help him do that now. So I apologize for that.
Okay, Jeff, why don't you just give us some background? I understand in the pandemic it's become harder and harder to have in-person signings of wills, so what are we actually doing here?
That's correct. This is something that the Wills, Trust, and Estates section has been working on for the last year. Even prior to the pandemic, this is something that they were working on. Obviously, society has changed, and there's a lot of documents that we all sign in electronic forms, real estate documents. We are dealing with e-notary issues this year. This bill will allow for wills to be signed electronically with a number of protections in there to make sure that the existing protections that are there for wills are also allowed in the electronic setting as well.
Okay, I'm going to ask for questions in just a moment, but I guess my very first question is, typically a will in Virginia, in order to be effective, has to have 2 witnesses. So how do you witness an electronic will?
So that you would be witnessing it. I'm trying to pull up the information. I apologize. And again, our subject matter expert that is working on it is trying to get in the room now. So, but he's having some trouble. So I'm doing my best here. And
Mr. Chairman, I believe that language is on page 18 of the substitute, line 476. It can be signed or witnessed in the electric presence of the testator by 2 competent witnesses. So it would be just like we're doing right now with a Zoom and me watching Jeff sign his will, and that it would happen under the e-wills bill.
Okay, I'm looking for that right now. It's not easy trying to read on this computer. Okay, let me ask a couple follow-up questions. How do we guard against fraud? Obviously we've had issues with wills being signed under duress or wills being signed when there's diminished capacity. What are the checks and balances here to make sure that if somebody can't appear live in your law office, that they do have the capacity to do what they're doing?
like I said, Mr. Chairman, I'm trying to get the information to our expert witness to be able to log in to the room and answer all your questions.
Okay, why don't we do this? I'm going to move you all to the back of the committee, since it seems like you're missing your prime witness.
Mr. Chair?
Yes.
Matthew Farley is joining the room right now.
Oh, okay. Hello, Matthew.
There he is.
Under duress or wills being signed when there's diminished capacity. What are the checks and balances here to make sure that some
Matthew, there was the Senator Peterson. Maybe you can repeat your question.
Yeah, my question is, there's always questions about fraud when you have wills done. What are the checks and balances here to make sure that somebody, when they sign a will, has the mental capacity to do that?
Thank you, Senator. Can y'all hear me?
Yes.
I'm sorry I was late. I could hear y'all, but I couldn't get into the meeting room. So to answer your question about fraud, I'm going to give you a general answer first, in that when we drafted this legislation, we sought to make the rules and procedures that apply to electronic wills the same as they are to paper wills, on the theory that this is the same type of document, just in a different medium. Obviously, with electronic documents, you can't have everything the same as a paper will, but and we were very cognizant of the issue of fraud and undue influence. So to go back to the earlier question, one thing is we require that for there to be electronic presence, the testator, the witnesses, and the notary must be able to see and hear each other in real time as if they were physically present. So you've got that. And then secondly, the main difference between the legislation as we drafted it and the Uniform Act is that under the Uniform Act, an electronic will may be witnessed or notarized. Doesn't have to be both. And that's true. Well, a paper will has to be witnessed, but does not have to be notarized. We added the requirement that an electronic will must be witnessed and notarized. Okay. And also, at the same time that it's being notarized, it would be made self-proved, meaning the notary is going to put the testator and the witnesses under oath and ask them a series of questions about the execution requirements. So that's one area where we stray from paper wills, but in a way that it makes the execution requirements more stringent, with an idea to protect against fraud, in light of the fact that this is being done in an electronic medium.
Mr. Chair.
Yep. Senator Obenchain.
And I don't know whether you want him to answer all the way, but I've got a question about that particular component of his answer.
Go ahead.
So, do witnesses have to be in the same place as the testator?
They do not.
Does the notary have to be in the same place as the testator?
No.
So is there any way to ascertain, other than asking the testator, to ascertain whether somebody else is in the room with the testator, like the caregiver, like somebody, a family member who's jumping line?
A family member who's what? I'm sorry.
A family member who may be exerting undue influence, standing in the back of the room.
That not within the sight of the camera, there would not be.
All right, thank you.
Mr. Chairman, Serville.
Senator Serville.
Thank you, Mr. Chairman. First of all, I believe this, if I'm not mistaken, if somebody can correct me if I'm wrong, that this act is purported to be the Virginia version of the Electronic Wills Act. Is that right? I guess it's a question for the witness.
That's correct.
Okay, sir, am I correct that there's only 2 states in America that have adopted this so far, Colorado and Utah?
Correct. And I believe it's Florida and Pennsylvania also have adopted their own version of electronic wills legislation.
Okay, thanks. And then my next question, sir, is I'm not clear why. I remember about 7, 8, 9 years ago, we went around and round and round and round authorizing electronic notarization. And I was curious as to why electronic notarization was not adequate to solve the problems of executing wills without having to come to close physical proximity to witnesses, which I assume is what's motivating this.
That, I think that's one of the things that's motivating it. And to answer your question, is that the witnesses, you can notarize lots of documents without witnesses, but the will must be witnessed. So having an electronic notary only does not solve that problem, at least completely. That's to Senator Obenshain's point, that you can look at this, I believe, in a couple of different ways. Maybe that you would want certain people to be in the physical presence of the testator, but that doesn't address, if that were the case, that doesn't address the issue with not having people in physical proximity to one another.
Okay, does that answer your question, Senator Serville?
A little bit.
A little bit, okay.
If I might just interject very quickly, there have been at least, just to the history, there have been at least 2 prior bills introduced in, I think it was 2017 and 2018, that would authorize electronic wills. I think it was in 2017, the Legislative Committee, the Wills Trust and Estates Legislative Committee, asked that those be go by while we studied the issue, which we did for 2 years. And at the end of that first year of study was when COVID hit. And there was a lot of interest and a lot of folks, both legislators and other interested parties, who contacted our committee and said we need to do something to permit the electronic execution of wills, especially in light of the fact that you can execute trust agreements electronically, powers of attorney electronically, and you can obviously make beneficiary designations and TOD designations. You can do all of those things electronically. So in some respects, wills are sort of lagging behind all the other estate planning documents that we deal with every day.
All righty, thank you. I'm going to ask one last question. We'll see what other witnesses we have. I understand, I've read through the legislation. I understand the need for it. I guess my question would be, to me as an attorney, I still think it's important to have people present live when it's possible. I just think as an attorney, you have a better idea of what's going on. You have a better idea of what the client's actual intent is when you have them sitting in your conference room as opposed to appearing on a TV screen. So I understand the context, I guess. Is there a way of incentivizing it so that not every single will signature from now forward will be by Zoom as opposed to meeting in person?
Well, I think we've done that a little bit already, to the extent that the Uniform Act makes it much easier to execute an electronic will than our proposed legislation would. And I think, we've got a few requirements that aren't necessarily intended to disincentivize the creation of electronic will, but I think they'll have the practical effect of doing that. I don't know that you could come up with the provision that says you can only make an electronic will if you can demonstrate that, making a paper will is impractical or unreasonable. Right. That doesn't seem to work to me. And my personal belief is that I think we're not going to see a great swing from paper to electronic, if for no other reason that the probate provisions of this statute require a paper copy in order to have a certified paper copy in order to have the electronic will admitted to probate. And so I think it's necessary legislation. I think it's good to have this option, especially in light of the fact that we transfer millions of dollars electronically at death already. And I think there are a few disincentives. But I don't know, Mr. Chairman, to get to your point directly, I don't know of anything expressly that you could do to say this is the option of last resort.
Okay. All right. I appreciate that. Any other speakers that are signed up to speak on Senate Bill 1435? We have anybody in the waiting room?
At this time, Mr. Chair, it does not appear there are any other. I take my words back. Nope.
Okay, so we don't have any other speakers. So
Mr. Chairman, I have one more question.
Senator Servo.
Thanks, and I'm sorry, I've forgotten the witness's name, but I'm just trying to understand how this would work. You know, I've been doing these depositions by Zoom now for the last 6 months. I actually conducted a 4-day trial by Zoom, and you know, I remember at one point I was examining a witness, and his microphone was off, and we asked his microphone to unmute, and it magically unmuted, at which point I realized there was somebody else sitting in the room with him, probably telling him what to say. And so I'm trying to understand, how is it that if we're doing this electronic will, and I got the person who's signing the will on the other side of the screen, how do I know that he's pushing or she is pushing the buttons on the computer? Like, that's what I don't understand. Like, how do I know, you know, that somebody's not sitting there telling them what to do or doing it for them or whatever? That's what I don't understand.
Well, Senator, two comments, one general and hopefully one specific. The general comment is that for just about every type of horror story that I could come up with for how an electronic will could be abused, I think there is, if not the same, certainly a similar situation where paper wills could be, you know, executed erroneously, fraudulently, forged. I've had that case. And so this is just something I wrestled with as we were studying this, that my initial inclination was to come up with all the ways that electronic wills could be abused. And the truth of the matter is, I don't think there can be abused much more than paper wills could be. So that's the general comment. The specific comment is by requiring an electronic will to be electronically notarized, that automatically brings in the e-notarization statute that Virginia's had for over 10 years. And the notary, I think you're correct. There's no technology I am aware of that would allow us to see the testator click a mouse that adopted their electronic signature. But we do have in the e-notary statutes a lot of identity confirmation requirements, which I believe are even being amended this session. And so the e-notary will have confirmed the testator's identity, and and the witnesses, and they will be able to see the testator in real time. Maybe not the thumb click on the mouse, but they will be able to see the document being signed. It will appear, the signature will appear on the document, which is on the screen that everyone can see. So I don't, again, that may not address all of your concerns, but I hope it addresses your question.
Okay. All right.
He addressed my question, Mr. Chairman.
Mr. Chairman, one last question.
Senator Obenshain.
Does this require that the will be written by an attorney, or that an attorney supervise the execution?
No.
Thank you.
Okay.
I have a question.
Yeah, Senator Edwards.
Yes. Am I correct that neither the witnesses nor the notary in a self-proving will need to be physically present with the testator?
You are correct.
Give me an example of.
Or I'm sorry, did you say a self-proving will or an electronic will?
Well, in the case of a self-proving will, you need a notary, right?
Correct.
Okay. So neither the witnesses nor the notary need to be physically present with the testator, correct?
For an electronic will, correct.
Okay. Tell me how you would need this. I mean, wouldn't you need somebody physically present with with the testator? I mean, so many nursing homes, hospitals, and so forth, somebody's there. Give me an example of how you would need this. I'm having a hard time understanding that.
Of how you would need to have that statute? Well, the COVID example would be the testator in the nursing home who can't be with other people. Now, you might say you could have a staff member present, but you wouldn't necessarily have a staff member present if they were signing a paper will. So, I mean, I think COVID is the example of how people were alone and could not safely get within physical proximity to others. Now, the other non-COVID area, it would seem to me, Senator, is not necessarily a need, but a recognition that this is the direction that society is going in, that people want to engage in all kinds of business transactions from their sofa. And they don't want to come to the lawyer's office, even if they've had a lawyer involved. We had a lot of people who were trying to sign who were not in Richmond, and we were making arrangements for them to go elsewhere to find a notary and witnesses. Whereas if they had this, they could have signed it in their home.
I can see the notary issue, but I cannot understand why you would need not to have the two witnesses being in some proximity. I mean, I'm not convinced you need it, and I guess I need to be better educated. But
All right, we've spent about 30 minutes on this bill, so at some point I'm going to need a motion. And I'm waiting.
I'll make one.
Senator Obenchain.
Mr. Chairman, I see both sides of this. I think with COVID, we certainly have seen a need for help in getting things executed, but right now we're at a point where by the time this goes into effect, pretty much everybody in the age groups that are, I think, intended to be affected by this are going to be vaccinated. We also have the problem of elders being more isolated during COVID and I think more susceptible to the exercise of undue influence. I think that, we've been, and I have great respect for wills, trusts, and estates section, but I think we've been pretty reticent about being on the cutting edge of uniform laws. And I think because of some of these concerns, that maybe we ought to look at this for another year. This committee, and I understand that the wills, trusts, and estates section has looked at it for a while, so I would move that we recommend passing the bill by indefinitely.
Okay, I got a motion of PBI. Is there a second? I've got a second. I guess we do that by voice vote, or how do we recorded vote?
If I may call the roll.
All right.
Senator Lucas by proxy. Pardon? No. All right. Senator Obenchain. Aye. Senator Boysko?
No.
Senator Serbell? Senator Edwards? Mr. Chairman? Three yes, 4 no.
Okay, what I suggest we just go ahead and reverse the roll on a motion report. I'll make that motion. Is there a second? Okay, so why don't we just reverse the roll for reporting? This will report out on a 4-3, and we will not have witnesses at the committee. Do we have another committee, Mr. Chair? Wednesday? Yeah. So I will give a summary of the discussion, and we'll just go up and down on Wednesday. Okay. Thank you very much to our witnesses. Next bill, we're going to get to Senate Bill 1107, Senator Stanley's bill on medical malpractice and repeal of the cap. I know we had a substitute adopted during the committee. Is that correct?
That's correct, Mr. Chairman. The substitute.
And that substitute is now uploaded to LIS on Senate Bill 1209.
Senate Bill 1107.
1107, I'm sorry. Yep,
So-
1107. Okay, Senator Stanley already gave a spellbinding oration about this bill, so I'm not going to even attempt to duplicate that, but I know there are a number of witnesses, both pro and con, that have been waiting all day. And first of all, thank you. Secondly, why don't we have the witnesses come forward and try and keep your remarks to at a maximum 2 minutes, and less than that is great. And let's have the people that are in favor of the bill. So if you're in favor, why don't you go ahead and let them testify?
Would those in favor or speaking for the bill please use the Zoom feature raise hand to indicate that you want to speak in favor of the bill? Sheldon Hervey, go ahead.
Yes, thank you for the opportunity to speak this afternoon. I'd like to share with you my wife Nancy's story. You heard that name this morning as an illustration of why the malpractice cap in Virginia is grossly unfair in cases like hers, in cases like ours. On 22 October 2015, Nancy went in for elective back surgery with the only fear being that her back would still ache when it was finished. With the exception of chronic back pain, she was healthy and very active. A retired CIA Soviet nuclear power analyst, she was working full-time as a contractor for the National Geospatial Imagery Agency, or NGA, helping raise 2 teenage kids with me, her husband of 21 years, and advocating for children with dyslexia in Richmond and on Capitol Hill as a member of an organization called Decoding Dyslexia. During the surgery, the doctor coming in from the back nicked a stomach artery, and Nancy coded for some 22 minutes before they could stop the bleeding. She could easily have died in the operating room, but Nancy is a fighter and survived, albeit with an anoxic brain injury. Some 5 years and 3 months later, Nancy remains remarkably positive and continues to fight to get a little bit better every day, and I remain incredibly proud of her for that. However, she is still unable to walk or perform any of the activities of daily living independently, and she remains incontinent. She sleeps in what once was our dining room and has not taken a shower in our home since the day before her ill-fated surgery. My once brilliant wife struggles to remember what she had for breakfast, but still remembers the Chernobyl disaster and parts of our wedding day, thankfully. Our kids, who were 13 and 16 at the time of the injury, now help me take care of a woman who they love, but do not recognize as their mother. And in my 35th year of government service, I have 2 full-time jobs: federal manager by day and caregiver spouse on nights and weekends year-round. It's all very exhausting for us all. In July 2019, I was very thankful for the favorable jury verdict in our malpractice trial, but was somewhat disheartened that due to the cap, our net award was less than 10% of the projected economic costs for Nancy's life care plan, projections that were not disputed by the defense attorneys. Money will never change history, but the money we did receive is going entirely to Nancy's care, quality of life, and safety. And an annuity will help defray about a quarter of Nancy's caregiver costs for the next 20 years. And we are in the process of converting our garage into a bedroom for Nancy with an ADA compliant shower and bathroom. Money well spent, yes, but in reality, it is not nearly enough to cover her medical and caregiver expenses. And what will happen as Nancy grows older and I become too old to work and/or take care of her? The legislation being discussed today will not help Nancy or my family, but I hope our story will raise some awareness that a cap on malpractice suits is unduly harsh to those who sustain catastrophic and permanent injuries and to the families who love and tend to them. It is difficult enough for them to grieve what has been lost. Please don't add insult to the injury by making them pay for it as well.
Thank you, sir. Thank you very much for testifying. Other people, proponents of the measure?
Sarah Huckins, please unmute and go ahead.
Hi, my name is Sarah Huckins, and I am one of the multiple juror members who are here today in support of SB 1107. And I think for me, it was a 2-week trial, and we heard evidence from both sides. And we determined compensation that was fair and just to our determination, but that was not upheld. And so I am in favor of this bill to cancel the cap so we can uphold the jurors' determination. Thank you.
Thank you for appearing and thank you for jury service. Next, proponents of the bill.
Chris Sarampot.
Good afternoon. Thank you for the opportunity to speak. I'm Dr. Christopher Sarampoti, and I served on the jury as well for Mrs. Hervey's case. I served on the jury with a group of thoughtful, intelligent people. We contributed a significant amount of time and energy, devoting 2 weeks of our lives. For us, the finding of fault was relatively brief. The case was clear. In contrast, the measured calculation of damages took time because we wanted to get it right. I cannot underscore enough my appreciation for the immense level of pain, the high financial costs, and the emotional impact this event caused to Mrs. Hervey, as testified by Sheldon Hervey. As someone who has worked as a clinical psychologist with families in neurorehabilitation settings, I know the toll for patients like Mrs. Hervey is great. As such, I was shocked and angry to find out afterwards how relatively little money Mrs. Hervey would ultimately receive. This was a punch in the gut. We had worked so hard to fairly arrive at an award that would not only provide for the medical costs for Mrs. Hervey, but one that took into account the life-altering effects of her injury and care, as well as the loss of intellect and ability for a skilled and talented human being. I was dumbfounded how my state could adhere to a practice that seemed so skewed to the detriment of my fellow citizens. It felt morally wrong. As someone trained as a clinical psychologist and whose wife practices as a clinical psychologist, I'm aware of the ramifications this bill might have. I've worked with some of the most vulnerable patients, and yet I know that any caring practitioner would want what is in the best interest of their patients. We work to deliver our services in the most careful manner to ensure that our patients' lives are better for our efforts. When those efforts fail catastrophically, patients like Nancy Hervey should be adequately protected. Thank you.
Thank you, Doctor. All right, next, proponents.
Claire Walters.
Hello, I'm Claire Walters. I was also one of the jurors on Ms. Hervey's case. I just want to reiterate that we awarded the money we did because that's what Ms. Hervey's care would cost because of the catastrophic injury resulting from her surgery. And what I'm wondering is if someone doesn't have the money for the enormous cost of care resulting from an injury like this, what happens to that person? Do they just not get care? I can't imagine that that's the case. And if so, then do the taxpayers pay for it? And honestly, if that's the case too, that doesn't make any sense to me. I feel like the cost of care should be paid by the person who caused the injury, just like how any other injury is treated under the law in this country. For whatever reason, medical malpractice is not treated equally. And to be honest, I'm kind of dumbfounded why. If someone is injured by a tractor trailer, for instance, same injury, same trial, same judgment, the injured would receive the entire judgment in that case. However, in a medical malpractice case, for whatever reason, we have this $2.2 million cap. And clearly other states don't agree because, as I understand, Virginia is only one of 2 states, with the other being Nebraska, that has a cap on actual medical costs. And so that's why I am speaking in favor of this bill, and I urge you to bring Virginia in line with the rest of the country. Thank you.
Okay, thank you very much. Next witness.
Jessica Zuko.
Yep, good afternoon. I'm Jessica Zucall, the jury foreperson on Nancy Hervey's case in support of this bill. So I found out about the cap directly after the trial, and while I won't share exactly what was said, I can say I was personally outraged because there's a pretty big gap between the cap of 2.2 and the 9.3 million needed. And as Sheldon mentioned, this was uncontested by the defense. And because negligence was found, the onus of responsibility should lie with the negligent party. So for those in opposition, I invite you to really hear me when I say that legislation that privileges insurance companies, a billion-dollar industry, over the needs of a catastrophic injury victim is unjust. And not only is it unjust, It further victimizes a victim who has already suffered the ultimate loss of life. Nancy is physically alive. It's true, she's breathing, but she's no longer able to truly live, not like you and I. Supporting this bill will protect future victims like Nancy. And as a citizen of Virginia, I urge you to do so because it's the right thing to do. Thank you.
Thank you very much. Next person.
Are there any other who wishes to speak in favor of the bill? Please raise your hand. Stuart Nagurka, please go.
Thank you. I'm a resident of Arlington County, and it's an honor to appear before the committee to testify in support of legislation eliminating or at a minimum modifying the unjust and unfair cap on medical malpractice liability in the Commonwealth. I came to this conclusion after having served in 2019 as a juror in the circuit court here in Arlington. Our jury reached a unanimous decision that the doctor in the case was at fault and that his negligence resulted in the patient, Nancy, requiring 24-hour care the rest of her life. The doctor's lawyers did not dispute the lost wages of Nancy, some $600,000. The doctor's lawyers did not dispute the future expected medical expenses for caring for Nancy, more than $8 million. And the doctor's lawyers did not dispute the care thus far for caring for Nancy. So no one at the trial disputed these costs, more than $9 million. These are costs that have to be borne by Nancy and her family as a result of the doctor's negligence. After we were dismissed from our jury service, every member of the jury was stunned when we learned the Commonwealth's cap on medical malpractice liability will prevent this wronged woman from receiving her just reward. Look, this is not rocket science. Nancy was wronged. She has suffered physically, emotionally, and financially. Who is responsible? The doctor who caused the permanent life-altering harm. Who should pay for her expenses and suffering? It's the doctor's insurance company. Now, sadly, under current law, the company does not have to pay what's owed. Furthermore, the insurance company has no incentive to even negotiate a settlement, as it knows the Commonwealth is currently protecting it.
Okay, sir, can you wrap it up?
Client's actions. So if the insurance company isn't paying, I think this is an important point. Who's paying? I am. That's one of the reasons why I'm here. You're paying. We all are paying, because if the wrong patient doesn't have the resources, it's Medicaid. All of us, we're stepping in to pay for it. I understand the committee and your colleagues in both chambers are under great pressure from the medical community and the insurance industry. And I just want to say, be strong and be brave, and remember the pressure you are facing is nothing compared to the pressure and the unfair and unjust pain and suffering of Nancy and other wronged patients.
All right, thank you very much. Okay. I think that is all of the proponents. Time for the opponents.
Would those who would speak against the bill please raise their hand? Keith Hare, please unmute and go ahead.
Mr. Chairman, I'll be brief. My name is Keith Hare. I'm the president and CEO of the Virginia Healthcare Association, and we represent almost all of the nursing homes in the state of Virginia, and we are opposed to this bill. We've worked in concert with the trial lawyers on an agreement on the medical malpractice cap that we believe has been very good, and we would hope that everyone would stay with that agreement because of the many issues that will likely be stated by a number of others who are testifying.
All right, thank you very much. Next witness.
Dr. Art Veyer.
Mr. Chairman and members of the committee, my name is Dr. Art Veyer. I'm a general and colon and rectal surgeon from Prince William County, Virginia, and I am currently president of the Medical Society of Virginia and speak for our 17,000 physician members. We respectfully ask the General Assembly to oppose any effort to alter the medical malpractice cap. Given the deleterious effect that COVID-19 has had on the practice of medicine in the Commonwealth, altering the medical malpractice cap would force perilous financial hardship onto healthcare providers at a time when they need our support the most. I ask you to vote no on Senate Bill 1107, and thank you for your time and consideration.
Okay, next witness.
Scott Johnson, please go ahead.
Thank you, Mr. Chairman. Scott Johnson. I'm General Counsel of the Medical Society of Virginia. I thought it may be helpful, since we've got some new faces, to set the stage of how we got here. And I'll take you back to 1976 real briefly. We had a large medical malpractice insurance company, St. Paul, that probably wrote 95+% of the business in the state. And they decided they were going to stop writing, and Virginia was in crisis. And so the General Assembly came up with the concept of the medical malpractice cap, because they wanted to make sure that med mal insurance was affordable and that citizens of Virginia had access to quality care. And that is where they went. The cap has been challenged twice constitutionally and has been upheld by our Supreme Court both times. And as was mentioned by Mr. Hare, we in 2012 sat down with the trial lawyers and worked out an agreement that the cap would go from $2 million to $3 million between 2012 and 2032. I've been authorized by leadership of the Trial Lawyers Association to clarify that this is not their bill. They're not lobbying for this bill. They did not request a bill, that they're honoring the 20-year agreement. So when you look at insurance premiums today, there are three factors that dictate what physicians and providers get charged: the frequency of claims, the severity of claims, and predictability. And Senator Stanley's substitute, which he was kind enough to share with us in advance of this, basically upsets the predictability element of that. If you read the substitute, it basically would tell the trial judge that they don't need to apply the medical malpractice cap. It doesn't say all the money is going to go for medical bills. In fact, if this were to pass today, more money would go in the pockets of plaintiffs' attorneys the way this is drafted. So it is not the issue there. The other thing I want to clarify too is when you look at the facts of the case that Mr. Harvey shared, that was a trial, that was a jury verdict, but it was not a reduction to the cap by the trial judge, and said it was an order entered of settlement after the jury verdict. So I've also been asked to say on behalf of the Virginia Nurses Association, the Virginia Council of Nurse Practitioners, that they too are opposed to this, and we'd ask you to vote no. Thank you.
Thank you, Mr. Johnson. Next up.
I have a question.
Robert Bradshaw.
Senator Edwards has a question.
Yeah, Scott Johnson, I have a question. This is really quite limited, the way I see it, the substitute, to substantial or permanent loss or impairment of bodily function, 1. 2, brain injury. 3, substantial disfigurement or any other special circumstance in the case that warrants a finding that imposition of such limitation would deprive the plaintiff of just compensation for the injuries sustained. The limits on recovery as set forth shall not apply. It's really quite limited. What's wrong with that? From what we've seen, it'd be very limited in scope. Can you answer that question?
Sure. Mr. Chairman, Senator Edwards, I think the words that you just articulated in this bill are going to be very broadly interpreted, because there are no parameters that a trial judge would have as to when or when not they would use this. So as they are setting the insurance premiums that doctors are having to pay, they're going to look at how many times might a award not be reduced to the cap, and that's got to be factored in the price, so you don't have the predictability. So it may be short in length because it's only about 5 lines on the page, but the applicability, we believe, will be very broad. We've not had any actuarial studies for the implication of this language and what it would be on premiums. Obviously, as Dr. Vayer said, members of the Medical Society and others in the healthcare community are engulfed in COVID right now, and time to get an actuarial report is not manifest.
Mr. Chairman.
Senator Serville.
Question for Mr. Johnson really quick. You mentioned that, Scott, that the final order that was entered in that case involving my constituent appeared to be a settlement.
Yes.
First of all, it's my impression that the judge, based on our code, pretty much had no discretion about whether or not they wanted to reduce the settlement, the verdict amount to some number. But isn't it also possible that the insurance carrier and Nancy settled their case so the insurance carrier could avoid a challenge to the constitutionality of the cap itself?
Mr. Chairman, Senator Somerville, I guess anything is possible. I don't have information to be able to answer your question definitively.
Okay, thank you.
Okay, what other witnesses do we have that have not testified yet?
Yes, Mr. Chairman, you called on me earlier and I appreciate the opportunity to talk. This is Bob Bradshaw with the Independent Insurance Agents of Virginia.
Okay.
And there are hundreds and hundreds of companies writing property casualty insurance in Virginia, but very few are writing med-mal. Insurance companies don't have to write this insurance, and that's part of why we have the cap. According to the National Association of Insurance Commissioners, 10 companies make up 80% of the market. The top 4 companies make up 50% of the market. If just one of these companies leave, you again run into the affordability and availability problem that Scott Johnson mentioned earlier. And earlier a comment of it's a Wild West out there in other areas, but other claims are subject to policy limits also. So this is a little different, but not terribly much different. But we certainly don't want to run into the availability and affordability crisis that we had a number of years ago.
Mr. Chairman, question for him.
Senator Serville.
Sir, in preparation for this, I asked the State Corporation Commission's Bureau of Insurance for some statistics on the affordability of malpractice insurance because I keep hearing that we need this cap to keep insurance in an affordable place. And so one of the data points I asked the Bureau to provide me was to compare Virginia's malpractice premiums with Texas. In Texas, they have a cap of $250,000 on non-economic damages, but they have no cap on economic damages. So that, for example, in the case that you've heard a lot about today, Nancy might have had a $250,000 cap on pain and suffering, but she would have, I think it was $9 million in medical bills that would have been covered. So the data they gave me for Texas showed that in Virginia for internal medicine, the premiums in Virginia are a little bit lower on the high end, about the same on a little bit lower on the high end, a little bit about the same on the low end. For OBGYN, by the way, which has much more malpractice risk than internal medicine, the Virginia premiums range from $31,000 a year to $109,000. Whereas in Texas, which doesn't have a cap like we do, the premiums range from $25,000 to $101,000. In other words, it is cheaper to get medical malpractice insurance as an OBGYN in Texas, which has no cap, than it is in Virginia. So can you explain to me what this whole insurance affordability concept is when in states that don't have a cap, it's cheaper to get insured?
Go ahead.
No, sir, I can't, and only because I've been working in Virginia and concentrating on Virginia, and we've run into this issue a couple of times where companies have threatened to leave the state, and in some cases they have, making it more difficult to get insurance in Virginia.
Okay. Any more witnesses that have not testified?
Todd Parker, unmute and please go ahead.
Good evening, Mr. Chairman, members of the committee. My name is Todd Parker. I'm an emergency physician. I work in Hampton Roads and up on the Eastern Shore of Virginia. Most of the hospitals I work in are underserved hospitals with a complicated patient population. As an emergency physician, we see everyone 24/7, 365. We don't have any pre-existing relationship with our patients. It's very difficult work. And it's been the hardest year of my life by far. I will tell you, I'm a pretty strong guy. I flew for the Navy for 10 years before I went into medicine and spent time in combat. And this has been the hardest year I've ever seen professionally. So I'm here on behalf of the Virginia College of Emergency Physicians, and I'm representing over 1,000 emergency physicians across the state. And we believe that the agreement with the trial lawyers for now should be honored, that we should stick with it. It was done in 2012. It's one of the highest caps actually in the country. So with the states that have caps, it is absolutely one of the highest caps, and it increases every year. And we just believe that this is the year to stick to that. I see cases where things go wrong, and there's no question on both sides that we could work to improve the medical malpractice and the medical legal system in Virginia. But that requires a comprehensive solution, not a unilateral solution. With COVID, with everything going on right now, this is not the year to pile on to the physicians in the state. And, you know, I heard others that said that, you know, this is just something for insurance companies. No, it's not. It's not. It's for physicians too. And with everything that's going on, this just isn't the year to do it. So, you know, we would always be welcome to discuss ways to reform medical malpractice in Virginia to make it better for doctors, to make it better for patients. But this is not the year to pile on. Thank you.
Okay. Any other witnesses?
Brandon Sears.
There we go. I apologize. Let me get it pulled up. My wife and I started a for-profit small family clinic in Senator Stanley's district, oddly enough. And I did a little checking. We are not required to carry malpractice insurance, but we do. You won't be credentialed without it. But having said that, practicing attorneys in Virginia aren't required to carry professional liability insurance to protect themselves for errors that they may make. Currently, 8.93% of practicing attorneys in private practice in Virginia don't carry any. And I ran a list, and if you look at just the House of Delegates, private practice attorneys who are active, 31% of them carry zero. So my concern is that a patient may have a suit, but if their attorney makes an error or mistake, misses a filing deadline, something simple perhaps, they have zero recourse. The clinic we represent is a medically underserved area, as is the majority of Virginia. One last point is that my understanding, and I know there's a room full of attorneys, so hopefully you can elaborate, that if you have some loose affiliation with the University of Virginia, Eastern Medical School, or VCU, you fall under the Virginia Tort Claims Act, and there's a $100,000 cap and a 1-year statute of limitations. And if you also receive any federal grant money, you're under the Federal Tort Claims Act with sovereign immunity. So please correct me if I'm wrong, but based on the limited information I've read, I would appreciate an explanation of it. And as such, I'd appreciate this be passed by, or at least some differentiation from a surgeon versus a family practice, because you can't plan for unlimited medical claims. There's just no way. We actually bought my wife's policy 6 months early so she could remain continuously covered. So anyway, I respectfully ask you to table the bill. Thank you for your time, ladies and gentlemen.
Thank you. And I will simply say, as an attorney, one, I do have insurance.
Yes, sir.
I have
everybody in the Senate does, by the way.
Oh, well. And but there's no limits on claims against us, but that's the world we live in. But understood. Thank you very much. Any other witnesses?
Frank Iorno.
Thank you. I'm Dr. Frank Iorno, an orthodontist in Richmond area and current president of the Virginia Dental Association, and I speak on behalf of our 4,000 members. The VDA would also like to oppose for the reasons stated previously. No reason to belabor the argument even further.
All right, understood. Any other witnesses?
Sandy Chung.
Sandy
Yes,
Chung.
hi. Hi, my name is Dr. Sandy Chung. I represent the Virginia chapter of the American Academy of Pediatrics, representing 1,200 pediatricians in our state. Children represent about half of our Medicaid enrollees, and your pediatricians are taking care of those kids. As you know, Medicaid pays poorly, so pediatricians before the pandemic were struggling to maintain our businesses. The pandemic has made that so much worse. Our patient volumes are at like 50% of normal. And even this past week, I had to furlough employees. I had to announce another round of salary cuts. But we're working harder than we ever had before because that's what we're supposed to do. I'm old enough to remember what medicine was like, you know, before we had a good med-mal cap. And my insurance premiums back then were 4 times my current amount. So if that were the case now, I have 100 providers. Our med-mal insurance premium would be $1 million of additional expense to my practice. We don't have that. I also worry about the cost of healthcare because we know that that cost includes all the expenses related. And should the cost of malpractice insurance go up, that may cause the cost to go up completely. So anyhow, I understand the families need help, and we support that. But this isn't the way to do it, especially right now when we're all struggling. Please protect your frontline primary care providers at this time. Thank you, and oppose the bill.
Thank you, Doctor. Anyone else, proponent, opponent, anyone else that signed up to speak has not spoken yet?
Steve McCoy.
Thank you, Mr. Chairman. I'm Steve McCoy. I'm the Vice President and General Counsel of Patient First, which is based here in Virginia. We operate 76 medical centers in 4 states, and so we have some perspective on the effect that different malpractice environments have on our ability to recruit and retain primary care providers to see our patients. Among our 4 states of operation, Pennsylvania and New Jersey have no limits on recoveries in medical malpractice actions. We have a very difficult time recruiting and retaining primary care physicians in those states. We tend to lose them more frequently. And when we lose them, they tend to leave the state entirely rather than going across town to work for another healthcare system or healthcare provider. Over the past 2 years, I would characterize the shortage of primary care physicians in Pennsylvania to be at a crisis level. We're having a very difficult time finding doctors to see our patients. That is in marked contrast to the Commonwealth of Virginia. In Virginia, when a provider leaves our employ, it's very common for us to see them again 2, 3, 4 years down the road. And the reason is that they don't leave the state. They tend to go across town to a different practice, and often they come back. There's a shortage in primary care and primary care providers everywhere. I don't think that's a controversial statement. I think that's why you all see bills year after year trying to expand the scope of practice for allied health professionals like nurse practitioners. But the scale in Virginia is nowhere near what we see in other states. If you repeal or materially alter the malpractice cap, as this bill will do, you're going to exacerbate and accelerate the shortage of primary care providers and primary care delivery in the Commonwealth. And for that reason, I would respectfully urge you to vote no on this bill. Thank you.
Okay, thank you. Any more witnesses?
Brent Rawlings.
Okay, let's keep it short.
Yes, Mr. Chair, members of the committee, Brent Rawlings for the Virginia Hospital and Healthcare Association. We're opposed to this legislation. Not much more to add here other than to leave you with this. Cases like these, they're heartbreaking, and it's difficult for anyone to hear, but they were not uncontemplated when the cap was put in place. They were not unforeseen. It was a policy decision that was made, and I would just urge you all to treat this as a serious policy decision, not a carve-out for a specific kind of cases. We have these caps in place for a reason, and these are difficult decisions to make. But this is not a simple carve out. It would unravel the statute, and we ask you to oppose. Thank you.
Okay, let me ask you a question, Brent. Since I've got you on the line, you're going to get you get the obligation. We've had the Neurologic Birth Injury Fund for probably 25 years or so, and that basically sets up a fund whereby children that are born with lifetime disabilities as a result of the circumstances of their birth, they're cared for from the fund, and you can also make recoveries from the fund. How does that work vis-a-vis the med-mal cap? Is that totally separate from it? Is that a model that perhaps we could help out the situation like we just heard for Mrs. Hervis? What can you tell me about that?
Yes, Mr. Chair, I'm going to phone a friend here in a minute, but I would just say in general that there's clearly an interaction between the Medical Malpractice and Birth Injury Fund, and those sorts of ideas of different ways to approach some of these issues certainly is something that we should explore as a Commonwealth. As far as the technical issues around how that's related and accessing the Birth Injury Fund, I'd have to defer to others, but possibly Mr. Johnson could speak to that.
Mr. Chairman, this is Scott. Would you like me to?
Just give me a moment or two about how Birth Injury Fund works, and if that's a potential model for. And I'm not asking to bind you. I'm just, if I look at situations like the one that was described by this unfortunate lady that was given a lifetime disability worth, a value of $9 million in care, and it ends up on DMAS. how do we treat that situation, and could neurologic birth injury fund be a model?
Sure. So, Mr. Chairman, the birth injury fund was contemplated at the time the medical malpractice cap was launched to address those situations. It is there to cover birth injuries, but not all injuries at birth constitute or meet the definition of birth injuries. And a obstetrician or family physician that delivers children can elect to participate in the fund and pay a fee to participate, as well as a hospital can participate. It basically becomes an election of remedies. So if a baby was born and had a noxic brain injury and the obstetrician or the hospital participated in the fund, it would be a lawsuit could be filed, but oftentimes that's going to be referred to the birth injury fund for them to handle. There are some injuries at birth that the birth injury fund do not cover, and that would include a shoulder dystocia injury where the child, in essence, gets a mechanical injury at birth, and those are still covered in the legal system. The birth injury fund is funded by 3 payment sources. The obstetricians that deliver babies and hospitals that participate on a per birth amount. Secondly, there is a fee paid by the med-mal insurers and other property and casualty insurers in the state. And the third aspect of payment is physicians who are not delivering babies pay a smaller fee into that fund.
Okay, thank you. All right, I think that's all of our witnesses, and we've had about 30 minutes of testimony. I think this is now in the hands of the subcommittee. I've got a couple thoughts of my own, but do any of the members want to make a statement or ask a question?
Mr. Chair.
Senator Boysko.
Thank you, Mr. Chair. I find it really upsetting that we feel like the doctors are being pitted against the people who have suffered these debilitating and life-altering situations. And I am intrigued by your idea of setting up a fund or doing something so that we do leave those families as harmless as possible. And so I hope we could think of studying this or putting it into another posture where we can find a win-win.
Thank you, Senator.
Mr. Chairman.
Senator Servell.
Thank you, Mr. Chairman. First of all, I want to thank Senator Stanley for bringing this bill and allowing me to be his chief co-sponsor. And unlike his chief co-sponsorship of the bill we're hearing tomorrow, I'm not going to make any amendments to the bill I've agreed to co-sponsor. But I'll just say, Mr. Chairman, you know, this policy is one of the policies that's been on the books of the Commonwealth for a long time that has really troubled me. Effectively, the legislature has made the decision that when a certain group of people and businesses make mistakes, we're going to socialize that cost on taxpayers instead of isolating the cost on the people who cause the harm. And that is unlike any other harm that exists in our legal system. It's pretty much, as far as I know, except for, you know, government torts with sovereign immunity, it's the only one. And you know, I once had an epiphany about this. I once had a partner who made me handle a $50 million case while he took a trip to Korea. And I remember looking at that case. I'd never done that type of case before, and I looked at the thing, and once I realized what he had done to me, I called him up and I said, do you know this? Have you looked at this case? You know there's a $50 million problem? And my partner said, yeah, so what? I was like, well, our malpractice policy is only $5 million. And I said, and then he said, well, then don't make a mistake. And I thought, you know, sure would be nice to have a legal malpractice cap so I wouldn't have to worry about somebody taking my house if I make a mistake, but we don't have that. And without a malpractice cap, nobody has to worry about the consequences of their own wrongdoing because it's never a problem because they've always got enough insurance to cover it and their house will never be at risk, their family will never be at risk, they don't have to go bankrupt. And, you know, I believe that one of the things that causes people to behave more appropriately is exposure, is liability. And we don't have that in this situation, number one. Number two, Mr. Chairman.
Go ahead.
There are numerous studies that show that insurance rates have nothing to do with caps. Rates have to do with the bond market, insurance returns. Insurance companies basically play with massive quantities of money And when returns go down, they start squeezing the people that pay their premiums to get them paid. They have nothing to do with settlements or verdicts they pay out or whatever. In fact, the companies in Virginia have made billions of dollars in premiums that they haven't made in other states because of this cap. And from my perspective, the only people that benefit from this are mainly the insurance companies, number two. Number three, this cap causes many cases to go to trial in our system that would never go to trial in any other state because the carriers, I once had an adjuster brag to me, we win 3 out of 4 of our cases. We get 4 cases, $2 million cap on each one. We just know to set our reserves at $2 million. We're going to win 3 out of 4, take them all to trial, roll the dice. That's how it goes. Whereas in states that don't have the cap and they have unlimited exposure, that's what forces settlements and gets cases out of the system instead of causing them to spend lots of time in court. And so having a cap, it causes our court system to be clogged. Mr. Chairman, the next thing I would say is that this cap creates a bizarre incentive. I've had people tell me about cases where somebody will come in and the bills caused by the malpractice are so great, the bills themselves are higher than the cap. So like for example, in the case you heard, but if your bills are paid by the wrong carrier, the amount of liens on the claim, the amount of liens on the case are greater than the cap. So in other words, no lawyer will take the case because anything that's recovered will go to the government or to the carrier. And so that kind of person doesn't get any kind of justice because nobody will take the case because it's impossible for anybody to make money on it. It's a bizarre situation, right? Somebody horribly injures somebody, but nobody will take the case because there's too many liens on the case and the government will take the money. It's bizarre. And the last thing I'll say, Mr. Chairman,
yes, sir,
is that Virginia was the first state in the world, the first government in the world that constitutionalized the right to trial by jury. And if you read our Virginia Declaration of Rights, which was drafted by my constituent, George Mason, it says the right to trial by jury is sacred. It doesn't say that about free speech or the right to counsel or anything else. It says about the right to trial by jury. And it says in matters between men, the right to trial by jury shall be sacred. And that's because in our system of government, which we pioneered in the world, we decided that people should decide what these cases are worth, not legislatures. And I believe that this policy on our books as it stands today is unconstitutional, which is consistent with what many other Supreme Courts around the country have started to find over the last 10 years. And it's just a matter of time before a court takes this down if we don't do it ourselves. So I'm proud to support the bill, and I hope we can do more with it than just table it and study it forever.
Okay. Senator Edwards.
I kind of take a similar but not exactly the same view. Medical malpractice is not exactly the same as legal malpractice. Just because a doctor violates the standard of care and there's a terrible injury isn't necessarily the same as, I mean, it's hard to prove these cases most of the time anyway. But it may not be because you got a bad doctor. Just because you have a bad result doesn't mean you have a doctor that is a bad doctor. And I know the premiums are going up ridiculously. The insurance premiums just for a doctor are ridiculously high. I'm not sure what the solution is. We need to do something. The cap is, for some people, way too low. And like this recent case, this tragic case involving Nancy, I'm very sympathetic to that. I'm also sympathetic to doctors' situations. We need a comprehensive solution to this that brings the state in. I happen to have been on the birth injury board many years ago. It really doesn't work as well as it should. But we need something like that we need to bring society in, insurance in, and take a better, really a new look at this whole approach. I think we need to push this bill over to next year for further evaluation. I appreciate Senator Stanley bringing the bill. This is a tragic situation. We need to respect that. But I'd like to take a more comprehensive look at this whole thing and look at what our other states are doing too. So for that reason, I would recommend that the bill go by for the year and let's take a look at it and and maybe get some groups together to figure out how we can deal with this as a societal problem, not just a doctors or hospitals problem, but a societal problem.
Okay, thank you. Senator Edwards, I am very reluctantly going to second that motion, and let me just speak to it for a second. I've been taking notes this whole hearing. This law, it was a grand bargain that was struck between VTLA and Doctors Medical Society many years ago. 2012, I guess, was the last time. But they're not the elected representatives of Virginia. We are, and we're going to make that decision when the cap is going to get removed. It's not going to be 2021. We understand the pressures on the medical industry from the COVID situation. We understand the sacrifices the doctors made, particularly when elective surgeries were suspended back in 2020. So there's a lot of pressures, fiscal and otherwise, and I 100% get that. That being the case, I tend to agree with my former law partner, and yes, he was referring to me earlier. I don't think I don't think this is sustainable as a long-term solution. I do think we have a responsibility to people like the Hervey family, where you do have a quantifiable damage that's long-term over time, that's catastrophic. No, it shouldn't just default to the taxpayer. I do think it's possible for us to set up a fund for those relatively minor situations. I think we can also exempt maybe those providers that handle emergency situations where they don't have a choice, they're just pressed into service. But I do think there's just a lot here. I think what I'll take the liberty of doing once we get to the committee level is to ask the chair to have Boyd Graves or someone else come back with what other states are doing, because I think that the ice might be finally breaking on this issue. But again, I'm not prepared to repeal the cap in 2021, so therefore I will second the motion.
Mr. Chairman, I just want to make sure I'm clear on what your motion is, because I was poised to PBI the bill, but what did you say your motion is? I need to hear that clearly.
Carry it over for the year. Can't do that. Then it's passed by for the year.
Then my motion is to PBI then.
All right, so we have a motion and a second to pass by the bill. What's that? Gently. All right, clerk, call the roll.
Senator Lucas.
Aye.
Senator Obenchain.
Aye.
Senator Boysko.
Aye.
Senator Servell.
No.
Senator Edwards.
Aye.
Mr. Chairman,
Aye.
the vote is 5-1 to pass by.
Okay.
May I make this announcement on this one I made an error on counting?
Yes. John, why don't you go ahead and announce that?
On Senator Hanger's bills relating to wills, Senate Bill 1435, the vote was 3-3. I reported it incorrectly, so that motion failed and the subcommittee would report no recommendation.
Okay. All right. No recommendation. All right. That was Senate Bill 1435. So if you were following at home, there's no recommendation. That's going to bring us to our last bill, which is Senate Bill 1209. This is my legislation, so I guess I'll just, what I'll do is I'll just describe it, and then I know we've got witnesses both pro and con, so I'll just try and do this as dispassionately as possible. This is a bill that followed on legislation we had last year on wage theft, which I think we are all in agreement is not a good thing. But the remedy as it was set up last year included a paragraph that we originally stripped off in the Senate that later got put back in conference, which generally made, or just it did make, general contractors liable for subcontractors that don't pay wages or don't follow the Fair Labor Standards Act. So in other words, the liability would flow through to the general contractors, even if they had paid the independent contractors or paid the subcontractors the full amount of the payment, they could still be held liable for unpaid wages or other issues. We narrowed that down slightly. I don't have the bill in front of me, but my recollection was we limited it to certain situations. It has caused, and I do a fair amount of construction litigation, a lot of consternation in the construction business. I know there's a whole raft of subcontractors, general contractors, highway contractors out there who really need help on this. So the bill that we've brought basically would say that where there is a sworn or statement that the subcontractor has paid its employees and followed the law, that you're entitled to rely on that, so that when you, as a contractor, when you pay your subs, you've paid your sub. You don't have to do it twice. And that is the substance of the bill, basically putting that statement in place as a defense to any subsequent action. Now, having said that, I do believe that there's a suggested amendment that would take the word out for general and just make it applicable to all contractors, so it's not just general contractors. And I don't have the bill in front of me, so maybe one of the witnesses could tell us what line that would be, and we'll get to that. Oh, it is...
Say line 45.
I think it is on line 44, it shall be a valid defense if the general contract, but then that would make change on line 40 to 41, strike general and just make contractor. And John, and Senator Edwards has another amendment, but let me get to that separately. That's separate. So if I could get a second to just drop the word general for lines 40 and 41.
Mr. Chairman.
Line 44. Yes, sir.
You know, in Section A, you have a definition of general and subcontractor, but no definition of contractor. I don't know whether this is something Kristen can look at, whether you achieve your purpose just by dropping the word general from 44, or whether we need a combined definition, create a term of art.
All right, that's a very good point, that the word general contractor and subcontractor what are defined at the top of the statute. All right, why don't we do this? Before I move that amendment, let me withdraw that motion. Let's get to the witnesses first, and then we can have the committee.
Mr. Chairman, I have a question for you, which also might help guide the witness testimony.
Yes, sir.
So I remember when this bill went through, and I remember you and I having sat next to each other on the floor talking about it a lot. And and I asked the people that came to see me earlier a couple weeks ago about this as well. When this bill went through, I thought the way that general contractors would mitigate their risk in these scenarios would be just to bond off the risk.
Right.
Is they would just get subs to go get a bond to ensure their payment of the payroll, and then that would just get built into the contract costs, and that would take care of the problem. And when I raised that with the people that came to see me who were supportive of this bill, they didn't seem to know what I was talking about. And so it would be helpful for me to understand why that's not a solution. And I don't know if you want to take that on or whether you want the witnesses to take it on, but that's something I'm looking to hear.
Okay. Two things. First of all, well, actually three things. I think you're right, and that's something we raised last year. Obviously, if you require a bond for every subcontractor, it's going to increase the cost of the project. Also, it's going to be a barrier to entry for a lot of subcontractors. They have to go out and get a bond that's going to be an amount of their performance, which, you know, that's going to keep a lot of small businesses from bidding on these contracts. Third, and I'm getting outside of my knowledge, but what people have told me is it's not easy to get a bond for non-payment of wages, but I will let them give the technical details on that. So that is certainly one thing we could do. All right, let's get to the witnesses. Why don't we start with those that are in favor of Senate Bill 1209?
Those who would speak in favor of the bill, please raise your hand in Zoom. Matthew Benka, please go ahead.
Matt Benka with the Virginia Contractor Procurement Alliance. Senator Peterson, what you just said was pretty true, is that for the most part, subcontractors very rarely get bonds. And if they did, it would be extremely difficult. And typically they aren't offered for wage theft issues. So that's my attempt to answer that question. And I hope others will as well. Several problems with the legislation last year. It creates a requirement that contractors become the policemen for enforcing wage theft. We, the contractor, are now liable for our subcontractors' payment of wages. That is a very big and heavy burden on us, financially as well as just paperwork. Two, a separate problem with the legislation is that it puts the contractor and their subcontractor at odds with each other. It creates a frictious relationship. The relationships between contractors and subs are in many cases multi-generational. The last thing you want to do is to create friction between the team. Third, the problems with last year is that straight up, it's very costly. Most businesses will be required to hire at least one new employee, depending on the size of the company. So very burdensome, very expensive. Number four, problems from last year. There are almost no real reported problems with wage theft. No one wants wage theft. But even the unions in their own presentation have shown that there are less than a handful of companies that have been doing this. And all of them that I've seen are from Northern Virginia and companies that most people have never even heard of. Five, in terms of the problems with last year's legislation, this will do an undue harm to the very small subcontractors and contractors, especially minorities and such. There is another alternative to wage theft going through the General Assembly right now. Delegate Krizik has a budget amendment which would create two positions in the Department of Labor, which would look for wage theft and investigate and prosecute. This is what should have been done to begin with. If the government believes there is a problem, this is why we have taxpayer dollars to help fund the problem, not to put the burden on the contractors. The list of supportive groups of this bill are huge, and I just want to go through them real quick. The Virginia Contractor Procurement Alliance, Associated General Contractors of Virginia, Virginia Associated Builders and Contractors, Virginia Association of Roofing Professionals, NFIB, Coalition for Procurement Reform, the Roanoke Regional Chamber of Commerce, Hampton Roads Utility and Heavy Contractors Association, Richmond Area Municipal Contractors Association, Old Dominion Highway Contractors, Virginia Transportation and Construction Alliance, the Virginia Ready Mix Concrete Association, and the Home Builders Association of Virginia. So we hope you'll support this bill. It's very important for the contractors in the state. It's our most important this bill. And just know that as an industry, we do not want wage theft, but the burden should not be put on us. Thank you for your time.
Thank you, Mr. Benka. Anyone else testifying in support of the bill?
Robert Bohannon, please go ahead.
Mr. Chairman, Rob Bohannon representing the Virginia Transportation Construction Alliance, as well as the Richmond Area Municipal Contractors Association, and the contracting community that builds and repairs Virginia's infrastructure is focused on reputable efforts to build and maintain that infrastructure. We also want to build future projects in the Commonwealth. VDOT has a number of provisions to ensure workers on transportation projects are protected from wage theft through things like weekly certified payrolls, Davis-Bacon wages, and regular audits to ensure both state and federal compliance. Transportation contractors who are honest, forthright, are not honest or forthright are subject to fines, liquidated damages, and even disbarment. We appreciate Senator Peterson bringing forth this bill this session. Thank you.
Okay. Other witnesses, if we have witnesses in support.
Brandon Robinson, please go ahead.
Evening, Mr. Chair, thank you, and members of the subcommittee. Brandon Robinson with the Associated General Contractors of Virginia. I would mostly associate my comments with the groups who spoke for and thank the senator for bringing this bill. And I would just add, additionally, it fixes a few issues that we've enumerated with last year's bill. One that we haven't talked about yet, but currently the law that was passed last year makes general contractors and contractors in Virginia liable for the wages of suppliers at manufacturers in other states. So there is language in this bill that fixes that as well. But essentially, what this does is it doesn't dump the responsibility of policing the crimes of the bad actors in the lap of the good contractors. So with that, we would ask you to support this bill. And again, thank you for bringing it forward.
Okay. Anyone else testifying in support?
Julia Hammond, please unmute and go ahead.
Good evening, Julia Hammond on behalf of Associated Builders and Contractors of Virginia chapter. The comments before us are exactly what we have to say. We support the bill. We appreciate Senator Peterson bringing it forward. We'd also point out that for those who think that this is somehow getting contractors and subcontractors around the rules, I would argue that it actually puts more pressure. If somebody were to falsify these documents, as the attorneys in the room know, we can certainly get in a whole lot of trouble for that as well. So it does protect the good actors. It draws attention to the bad ones, anyone who wouldn't be willing to sign such a document. And then if somebody were to fraudulently sign, or you all know the better legal terms, we can get in trouble for that as well. So thank you.
Anybody else in support? And then if not, we'll get to the opponents.
Greg Ackerman, please go ahead.
Mr. Chair and members of the committee, my name is Greg Ackerman. I represent 17 construction unions in the Northern Virginia area. I just want to first of all get at some of the issues with this bill and then talk about some of the points that were made by those in support. Some of the issues with this bill, basically that subcontractors that are harboring labor traffickers and that are not paying workers all wages due, not paying overtime, misclassifying workers, and all of the potential issues that arise on construction sites are not going to hesitate to falsify a document. We've seen that just with the last couple of months. There was recently a subcontractor doing work on a public construction site that falsified the logo of a state agency, which is many number of felonies. We've just found that in the construction industry, that there really isn't, this really is not going to be a deterrent for many of the unscrupulous contractors that unfortunately have found Virginia to be a very competitive marketplace for them. I want to get at some of the comments made by others, because I think most of the comments were aimed at the issues with the initial law, and I think our issues with the amendment make it seem as though this amendment is slightly disingenuous in that it's trying to essentially create a loophole. We would much rather discuss, just simply crossing out the initial language as opposed to talking about some sort of loophole that will take away all the liability away from general contractors. The idea that general contractors and subcontractors have to have a nice and cozy relationship and not have a frictional relationship, I think does a real disservice to the workers. At the end of the day, we're talking about workers that aren't able to put food on the table for their family. These are vulnerable immigrant workers. And if general contractors get mad at a subcontractor because they're not paying their workers and are therefore liable, I think that's an overall public good, and we shouldn't hinder our legislation on the idea that general contractors have to get along with their subcontractors. I strongly want to push back on this idea that there's no wage theft in Virginia on construction projects, or that it's not common. There's currently a lawsuit against contractors performing work at the new General Assembly building that has over 100 workers signed on. That is not unprecedented, but it is very uncommon to see that quickly that many workers sign on to any lawsuit, let alone a lawsuit alleging misclassification, vulnerable working conditions, unsafe working conditions, lack of not unpaid overtime at Virginia's own new General Assembly building. There have been a number of lawsuits all across the Commonwealth just recently alleging these very issues, and there has been a state work group that has affirmed that misclassification and wage theft is a huge problem in Virginia, and I would encourage anybody who doesn't think so to spend any amount of time on a construction site. I also want to push back on this idea that this bill has been undue harm on small contractors. There have been a number of small contractors, including those that I represent, that have complained actively about how they are dealing with an unfair market where bad actors are not punished, and where, as a small contractor, they have to play by rules that big contractors don't, and this simply levels the playing field. Finally, I do want to push back on this idea that what we need to do is just investigate wage theft more. At the end of the day, this is an issue that is pervasive on what we would estimate to be about 90% of construction sites in the Commonwealth. And so for a couple of wage theft investigators to be able to create an uncompetitive market for that type of activity, is not really reasonable. And so we think that the best way to do this is to ensure that workers get their money back, and that there is not a competitive advantage for unscrupulous contractors. And so we strongly encourage members of the committee to not support this legislation. Thank you.
Okay. Greg, thank you for that. Any other people testifying in opposition to the bill?
Sebastian, please go ahead.
Thank you so much. Thank you, Chair and members of the committee, and I echo a lot of the sentiments of Greg Ackerman here. I'm speaking on behalf of the Iron Workers Union in Virginia, representing over 2,000 members in 3 apprenticeship schools across the state, with our district office in Fredericksburg. I want to share our opposition to the bill 1209 and the amendment, because it would create loopholes for accountability in cases of wage theft by the general contractors, for which we work tirelessly already to enforce in our industry to protect our workers on many of our job sites. It would not be fair to our workers or apprentices in the industry who may be taken advantage of. We don't want to give bad actors another path out of existing laws and basically punish good actors or general contractors that uphold good standards for our workers and create an uncompetitive advantage. This would hurt the industry standards across the state for our workers, and many of our members could basically lose confidence in their trade. We should also not be disconnecting this liability, considering that general contractors and subcontractors already share a number of other liabilities when it comes to OSHA regulations or workers' compensations. So we asked the committee to oppose this amendment in this bill. Thank you.
All right, let me ask Sebastian, I guess you and Greg are both there. The existing law, the law right now says it does not apply, it only applies if the general contractor knew or should have known that the subcontractor was not paying his employees. So there's already a loophole in the law, so to speak, that if someone says, well, I didn't know he wasn't paying his employees, I mean, isn't he free from liability right now?
Mr. Chair, yes, they could make that argument in court, and it would be up to the judge to determine whether that's a valid argument. The issue with this amendment is it essentially says that a valid argument only requires a subcontractor to sign a piece of paper. And so you're right, and I believe we talked about that amendment last year that would give general contractors a valid defense in court. And we believe that this is enough of a valid defense. If general contractors don't know what's going on their job sites, they can make that argument. But this is, we believe, far too an easy way for general contractors.
So fair enough. So Greg, basically you don't believe that if there is a certificate, because let's say I'm a general contractor, better yet, say I'm corporate counsel to a general contractor. I say, before you pay the sub, let's say you owe a sub $100,000 for putting on a roof. Before you stroke that check, you're going to need some type of certification from him. Ideally, you get an indemnity bond, but you may not be able to obtain that. He may not be able to afford, but you get some certification from him that he has paid all of his employees pursuant to Davis-Bacon, FLSA, whatever applies. In other words, you don't write that check till you get that certification. You would agree with me that would have some relevance in a court case, correct? You just don't think it ought to be conclusive.
Yes, Senator, and I don't know how that comports with prompt payment laws. Obviously, there are prompt payment laws that exist for general contractors to pay subcontractors, and that agreement would obviously have to comport. You can't just withhold payment. I don't believe currently you can't withhold payment on the condition that a subcontractor has paid all its workers. I don't believe so, but you can also include an indemnity provision in the contract. So if the general contractor does have to pay workers damages as a result of some lawsuit, then that general contractor can exercise its indemnity rights, and they can include that in the contract, and so that subcontractor can be liable in that instance. That would be the way around it.
All right, I appreciate that, and ironically, Greg, I think this sets up the classic case of employees who may be immigrants versus small business owners who also may be immigrants, by the way. Either one of them is going to be impacted by this legislation, because there's no doubt that at the bottom, in the construction industry, it is heavily dominated by immigrant businesses. So, all right, well, listen, I think the bill's been fully explained. Senator Edwards had an amendment that he was going to suggest that I am going to report it says, if you go to line 44, and I think this kind of gets into what I was talking about with Greg, instead of saying it shall be a valid defense if the general contractor obtains a written certificate, instead strike that, and instead it will say, as evidence, a general contractor may offer a written certificate under oath, and then from the subcontractor in direct privity of contract. So that would be in line 44. As evidence, a general contractor may offer a written certificate under oath. So I would go ahead and move, or actually, Senator Edwards, you make that motion? Make the motion to amend it, I second it. All right, we have a motion and a second to make that amendment on line 44. All in favor say aye. Aye. Any opposed? All right, that motion carries. So now we have the bill as amended, and I think it's fair to say that kind of takes it out as from a conclusory to just simply saying this will be a piece of evidence. All right. So that now we have the bill before us as amended.
Mr. Chairman?
Yes, Senator Serville.
Sorry, could somebody read to me what the sentence now says?
It will say, after 500,000, period, next sentence, as evidence, comma, a general contractor may offer a written certificate under oath from the subcontractor in direct privity of contract, on down the line.
Thank you.
Okay, so that was the first amendment. The other amendment was the general contractor versus contractor dichotomy. I'm going to hold off for now because I think Senator Obenshain had a good point that the code section is written to general contractors. That's a defined term, so I don't want to vary that till I get a little bit better information. So we have the bill as amended before us. Clerk will call the roll.
Is this to recommend reporting with amendment?
Yes, sir.
Senator Lucas. Senator Obenshain.
Aye by proxy.
Senator Boysko.
No.
Senator Serville. Senator Edwards. Mr. Chairman.
Aye.
I have 3 yeses, 1 no, and 1 abstention. 3-1-1. And now he says no. Lucas is no.
Okay, we have a 3-2-1.
Yes.
Okay. Obenshain, I had you yes on that. There you go. Report that resounding victory onto the full courts committee, and I believe that's all of our business. All right, the subcommittee will rise. Thank you very much.